As this hearing is fully virtual, I want to refresh everyone on a few housekeeping matters. It's been 22 hours since our last hearing, so I'm sure some of you might have forgotten. For today's meeting, the chair or staff designated by the chair may mute participants' microphones when they are not under recognition for the purposes of eliminating inadvertent background noise. Members are responsible for muting and unmuting yourselves. If I notice that you have not unmuted yourself, I will ask you if you would like the staff to unmute you. If you indicate approval by nodding, staff will unmute you. I remind all members and witnesses that the 5-minute clock still applies. You will notice the clock on your screen that will show how much time is remaining. When your time has expired, the clock will turn red and I will recognize the next member. Finally, House rules require me to remind you that you have set up an email address to which members can send anything they wish to submit in writing at any of the hearings and markups. That email address has been provided in advance to your staff. I'll keep my opening statement brief so we can get right to questions. This morning, we welcome the Honorable Rosalind Moskoff, the newly appointed Director of the Administrative Office of the U.S. Courts. Welcome. And the Honorable John W. Lundstrom, Chairman of the Judicial Conference Committee on Budget, to testify on the Judiciary's fiscal year 2022 budget. I would like to start this hearing by talking about transparency. At a time when faith in our institutions is at an all-time low, government transparency is critically important. From my years in the courtroom, I believe that the greater public access to federal courts increases accountability in the judicial system and in turn strengthens transparency and helps restore faith in our democracy. I am pleased that the Judicial Conference has expanded their policies to live stream audio in circuit courts and selected proceedings in civil cases. And in March 2020, the CARES Act authorized the Judiciary to live stream video for specific criminal proceedings. These are all steps in the right direction. However, I'm concerned that these measures are seen as a temporary fix to continue judicial operations during the pandemic. I wish to encourage the Judicial Conference to explore the benefits of permanently expanding its live streaming policies, creating more ways for the American people to view and understand our democracy in action, and it's absolutely critical to our success. Turning to the reason for this hearing, the budget, we appreciate the submission of your fiscal year 2022 request totaling $8.1 billion. I've long been an advocate for ensuring the judiciary is properly funded. Sufficient funds for our judicial system should not be a partisan issue. I look forward to discussing how the requested funding supports the judiciary's priorities. I'm interested in learning more about the Defender Program in light of last year's Supreme Court decision that has referred a substantial number of state cases to federal prosecutors, thereby flooding the federal defender system. And I would like to learn more about the progress made on improving workplace misconduct procedures at the judiciary and on standing up a robust new Office of Judicial Integrity. I know this budget was prepared close to 2 years ago when the thought of teleworking was a novel idea and not a necessity. So I hope we can use this time today to discuss evolving IT needs. We also need to talk about physical security needs and any necessary supplemental funds. Just as it did for the legislative branch, the insurrection on Capitol on January 6th raised some serious concerns about the safety and security of our hardworking judges and staff, and physical security needs in and outside the courtroom, as we saw with the tragic shooting at the federal judge's home in New Jersey. Once again, I thank you for joining us this morning and look forward to your testimony. I now turn to our ranking member, Mr. Womack, for his opening remarks.
Thank you, Chairman Quigley. Judge Lundstrom and Judge Moskoff, thank you for appearing before our subcommittee today. The rule of law is the bedrock of American society. Our founders wisely designed our judicial branch to protect our constitutional rights and both faithfully and impartially uphold justice for all. An independent judiciary that holds the trust and respect of our citizens, that can resolve criminal, civil, and bankruptcy disputes in a fair and expeditious manner, is fundamental to our nation. In addition, each year, the judiciary's probation and pretrial service officers perform a critical public safety mission by supervising over 200,000 offenders and defendants living in our communities. I know that the COVID pandemic has had significant impact on court operations. In the midst of great uncertainty, judges and court staff have worked diligently to continue the work of the American people. Regarding the Judiciary's budget request, I'll work with Chairman Quigley to ensure you have the resources needed to accomplish your important mission. However, let me say that with the national debt approaching $28 trillion and certain to grow exponentially in the future, I believe this committee must take a careful look at all federal spending and responsibly reduce expenditures where we can. And where we can't, we've got to make sure that we're completely accountable. We have a moral obligation to future generations to get our fiscal house in order. That will certainly mean making some tough choices and discerning carefully between the wants and the needs of the federal bureaucracy. I appreciate the important work the judiciary performs, and I look forward to your testimony. And Chairman Quigley, I'll yield back the balance of my time.
Thank you, Mr. Womack. And we now turn to our witnesses. Without objection, your full written testimonies will be entered into the record. With that in mind, we would ask you to please summarize your opening statement in approximately 5 minutes. We'll start with Judge Moskoff's statement.
Thank you very much, Chairman Quigley. And to you, Chairman Quigley and Ranking Member Womack, and to the members of the subcommittee, I'm pleased to appear before you today for the very first time as Director of the Administrative Office of United States Courts, a position I assumed only 3 weeks ago. I have been a district judge in the Eastern District of New York for over 13 years, serving as chief judge for the last year. I've been in public service for over 38 years and look forward to continuing that service in my new role as director. I'm here today to present the Administrative Office's fiscal year 2022 budget request, which totals $100.3 million, and it is discussed in detail in my full written statement. These funds will enable us to continue our work facilitating national programs and policy processes and supporting courts, probation and pretrial offices, and federal defender organizations around the country. Some of our recent accomplishments include supporting the branch's response to the COVID-19 pandemic, improving policies and procedures relating to workplace conduct, and furthering efforts on diversity and inclusion in our branch. I also serve as the secretary to the Judicial Conference, and in that role, I offer my support for the budget request of the entire branch and ask for the subcommittee's assistance on a few Judicial Conference priorities beyond the Judiciary's budget. The first of these requests is the continued extension of 8 temporary district judgeships whose authorizations would otherwise expire in 2022. In the absence of a comprehensive Article 3 judgeship bill, and to avoid significant disruptions and workload burdens that would follow from the loss of these temporary judgeships, this subcommittee has worked with us to extend them in your bill each year. And we are grateful for your past support for these extensions and continue to ask for that support in fiscal year 2022. The second Judicial Conference request is the provision of the necessary resources to the General Services Administration so that they can execute the Judiciary space priorities adequately. In fiscal year 2022, those priorities include funding for a capital security project in Augusta, Georgia, and the construction of a courthouse annex pursuant to a judicial space emergency in San Juan, Puerto Rico. We also seek the continued funding of 2 new courthouses and sufficient repair and alteration funding to begin addressing GSA's backlog of deferred maintenance projects at judiciary occupied facilities. The final Judicial Conference request relates to judicial security. And as Chairman Quigley noted, 7 months ago, an aggrieved litigant murdered the son of U.S. District Court Judge Esther Salas and critically wounded her husband. This incident came amidst a trend of rising threats against judges, as well as sustained civil unrest and several violent incidents occurring at or near federal courthouses. Focused on the need for urgent security upgrades, the Judicial Conference approved and transmitted to Congress last summer a number of proposed improvements and included both authorizing legislation and a request for additional funds for the Marshal Service and the Federal Protective Service to better protect judges both in and outside of the courthouse. We've made progress on several of these items and hope to build on it this year. And while these improvements are largely outside your jurisdiction, we would still value your support as we pursue them with the relevant subcommittees. And finally, we've also identified additional resource needs in the Judiciary's court security appropriation following lessons learned from the January 6th assault. These requirements came too late to be included in our fiscal year 2022 request, but we hope to work with you going forward to find a way to address them. Let me again thank you, Chairman Quigley and Ranking Member Womack and all of the members of the subcommittee for your ongoing support of the administrative office and the entire judicial branch. And as you make the difficult choices to apportion the resources at your disposal, I would ask that you keep in mind the unique constitutional role of the judiciary and the importance of its effective functioning to our democracy. Thank you very much for the invitation to testify, and I would be happy to answer questions.
Thank you, Judge. 3 weeks, we welcome you. We want a full report on those 3 weeks. And in the meantime, we're glad you're here, and we'd like to hear from Judge Lundstrom.
Thank you. Chairman Quigley, Ranking Member Womack, and members of the subcommittee, I'm pleased to appear again before the subcommittee this year to present the fiscal year 2022 budget request of the federal judiciary. I'm a senior judge in the District of Kansas, but I am appearing today as chair of the Judicial Conference Committee on the Budget. I will briefly summarize my prepared testimony about our discretionary appropriations requirements and our longstanding cost containment program. I would like to begin by thanking the subcommittee for its strong and consistent support of the judicial branch. We are particularly grateful for the funding we received in the fiscal year 2021 Omnibus Appropriations Bill. We know that you had many difficult decisions to make in constructing that bill, and we appreciate how we came out in all of that. Like other institutions throughout the world, the operations of the federal judiciary continue to be significantly disrupted by the COVID-19 pandemic. Most judiciary personnel are teleworking. Many grand jury proceedings and jury trials have been postponed. Civil litigation has slowed. Courts and federal defenders are using video and teleconferencing technology for criminal and civil proceedings, and probation and pretrial officers are using innovative approaches to supervise offenders released from prison and defendants awaiting trial. The judicial branch's more than 33,000 dedicated professionals, like public and private sector workers everywhere really, continue to perform their duties admirably during this period of great uncertainty. Although the impact on the nature of our workload has been significant, for example, filing of new criminal cases were down 11%, filings of bankruptcy cases were down 12%, and appointed counsel representations in our defender services programs were down 19%, commensurate with that decline in the filing of new cases. Not only do we anticipate the workload in these areas will rebound in 2021 as we continue to adapt our processes to keep dockets moving and as vaccinations become more widespread, allowing a gradual return to normalcy, but also certain pandemic aspects have created additional work that fill in some of those holes. In addition to the challenges of estimating workload during an ongoing pandemic, there's also a new administration whose prosecutorial policies and other criminal justice and immigration policies, which will directly impact the judiciary's workload, have not yet been fully implemented. Despite these uncertainties, we've endeavored to submit a budget request based on the best information available to us at this time. As new information becomes available, we will advise the subcommittee in a budget re-estimate of any changes to our fiscal year 2022 appropriations requirements. The Judiciary's FY 2022 request of $8.1 billion in discretionary appropriations represents an overall 5.2% increase above FY 2021. Nearly 85% of the requested increase is required just to maintain current services. In other words, the inflationary and must-pay adjustments to our budget needed to maintain current staffing and service levels in the courts and federal defender offices. One example, of course, is a 4% rent increase from the General Services Administration, which amounts to approximately $38 million, over half of which is to pay for enhanced cleaning of courthouses as a result of the pandemic. This is a cost we must pay. The remaining 15% of our requested increase is for targeted enhancements. We are seeking $29 million for additional staff in district courts, probation offices, and federal defender offices to address projected workload increases. We request $13 million for courthouse security improvements and additional security officers. $3 million will fund 6 additional magistrate judges and related costs. $9 million is to ensure courts have the latest IT firewall technology. $2 million is to restore funds for in-person training programs for judges and court personnel. And $5 million is for other initiatives, including further strengthening our risk management and contracting and procurement programs. Finally, I want to emphasize the high priority we place on cost containment. As detailed in my written statement, we have achieved significant savings by reducing space, requiring each judicial circuit to offset new space needs with reductions elsewhere, and through our partnership with GSA to address cost and service issues. We continue to expand the sharing of administrative services to resist duplication, and we are also achieving significant savings by promoting electronic noticing to litigants in bankruptcy cases instead of mailed notices. And we are looking at lessons learned from the pandemic for economies and process improvements that may be viable for the longer term. For example, a greater reliance on video conference for meetings and conferences, and perhaps a reduced travel time for defenders and appointed counsel. Again, thank you for the opportunity to appear today and for your continued support of the judiciary. I ask that you make a part of the record my statement and the statements provided by other judiciary entities on whose behalf we submit requests. I would, of course, be pleased to answer any questions the subcommittee may have.
Without objection, thank you, Your Honor. Judge Lundstrom, can you tell me a little bit more about your thoughts on the judiciary's progress for bringing video and live stream audio into the courts, and their help in creating additional transparency? We've seen some progress, but obviously a lot of that seems to be that which was necessitated by the pandemic.
I think Judge Moskoff can speak to that in an overarching way better than I can, actually. So if you don't
However
mind,
you
Mr.
want to
Chairman,
split it up is fine with me.
I can lateral this one over to her.
I'm happy to address that. Thank you, Judge Lundstrom, and thank you for that question. The transparency and openness is one of the hallmarks of our democracy and of our federal courts. And during the pandemic, our courts have made remarkable efforts to continue public access and transparency by using technology. We have been conducting, all of the courts of appeals have been live streaming their arguments. District courts have been providing audio access to civil proceedings, and through the CARES Act, both audio and video of certain criminal proceedings. So we have learned a lot, I think, both good and not so good. We need to take that information, but we need to really explore how we can continue to use technology to bring public access and transparency. There are lots of things that I think we need to address based on our experience. There are technological challenges. One of the things courts have very quickly stood up access, and not everyone is using the same types of technologies, and not all technologies work as well. There are resource constraints and budgetary impacts that need to be considered. I think not just on our end, but we've encountered executive branch issues in that realm. We also have to recognize that during the pandemic, we've been operating with a bit of a reduced caseload, and we've been conducting limited proceedings. So how our experience during the pandemic will translate into the future use of technology, I think, is something that we will explore and see where it takes us. And we do need to ensure that whatever we do, whatever practices we employ, they don't interfere with the proceedings, they don't undermine the integrity of those proceedings, and always ensure the fairness of those proceedings.
No, and I understand that. I guess the next question would be, is there anything that has happened during the pandemic, during this streaming that we've seen, that would make you say, well, we can't do this when the pandemic is over? I mean, are they going to continue at least where we are at this level?
So I think at the trial level, and this really comes from my experience as a chief judge, I took over, again, a few weeks before the pandemic hit. So my timing is never good on these things. But there are real challenges. Proceedings take a lot longer. Judges, because of limitations at the Bureau of Prisons, while we may be saving
resources. You mean they take longer anyway because of the pandemic, not because of the streaming?
Well, I think they take longer because of the technological challenges. People don't always tune in right away. The Bureau of Prisons has challenges producing defendants to the room, sometimes the single room where the video is located. The Bureau of Prisons has severely limited in many districts the type of technology that can be used. So there are ways that we may be able to employ technology to save time, to save resources, but we really need to think about what has worked and what hasn't worked during the course of the pandemic.
You know, I say this with the greatest respect. Everybody on this side of this hearing is during most committees, and certainly when we're on the floor, everything we say and do is shut out. And the beauty of our democracy, warts is all, is that transparency. So I just stress that it doesn't always look good. The trains don't always run on time, but it's still important. So we would like as much information from all of you as we can, so that we know what you need, what resources you need to move this forward, rather than hear it respectfully that it can't be done. But I appreciate your answers. And we now turn to the ranking member, Mr. Womack.
Thanks, Mr. Chairman. I'm going to lead with a question on probation and pretrial services. And I'm going to throw this open to either of the two witnesses that we have today. Specifically interested in how this pandemic has affected our probation and pretrial service programs. And here are the two or three pieces of this question. How has the pandemic impacted their ability to help offenders? Because we've got a couple of 100,000 of these that we supervise. How's the pandemic affecting basic things like housing, job training, employment opportunities? How's the pandemic impacted the ability of offenders to receive necessary drug and mental health treatment, which is huge? I have a question about recidivism rates. How have they been impacted during the pandemic? And how has the cost of providing effective supervision changed during the pandemic? So there you have a menu of several questions under this umbrella of pandemic impact on our system of probation and pretrial services. And I'm going to just allow both of you, if you care to, or either of you, to comment on those questions.
Well, I'll lead off, Ranking Member Womack, and the director can jump in whenever she feels appropriate, of course. But the pandemic has had a definite impact on the way probation and pretrial services have to manage their workload. Much of what prior to the pandemic was an in-person function of going out to people's homes or bringing people into the courthouse or wherever the probation office may be located to meet with officers. Individual drug treatment, individual mental health treatment, things like that that might be taking place in group settings, all involve interaction with people. And because of what's resulted from the pandemic, that's all had to be changed, and it has created quite a difference. Probation offices now are trying to minimize in-person contacts by using such things as individual drug treatment or individual mental health treatment instead of group. Of course, that's more expensive to do it that way. They've had to do more interaction by FaceTime or Zoom or some other virtual process to deal with offenders, which has its own challenges to it, including utilizing the defenders themselves sometimes to install monitoring equipment and that kind of thing to eliminate the interpersonal contact. So it has had a big impact, and it has had a cost element to it, especially. The best illustration of that is changing from group to individual drug testing. As you point out, most of the folks that come out of the penitentiary have been there with underlying drug or mental health issues, in my experience that I've been doing this for almost 30 years. And so therefore, in the post-release supervision world, addressing those issues is the most important thing, perhaps, for getting people on the right path to not reoffend. Another component of that also is often we find that folks really have not developed the same, shall we say, worldview, a moral compass, whatever. And so such things as moral recognition therapy, where people are taught one-on-one often or in group settings about just the right way to behave and who not to hang out with and all of that sort of stuff. Again, the way in which that's conducted has to be different. I think it's too early to say what the impact on recidivism may be. I certainly have not seen individually myself any increase in revocations of supervised release that I think are in any way related to the change in doing business during the pandemic. But it's really too soon probably to know whether there's going to be any long-term increase. We're very proud of our work and ability to have brought recidivism down. We believe we have a better record than the state courts generally, a decrease of somewhere to 4 to 7% from what would otherwise be expected of folks. And we're dealing with a higher risk population these days that are coming out. One of the things that's been done, both because of the pandemic and for cost containment, has been to terminate supervised release for low-risk offenders early. That, of course, means the mix of the population is higher risk. And as more people have come out in the higher risk category as a result of such things as the Fair Sentencing Act, the First Step Act, and so forth, that has increased the criminal history categories and the complications for supervision of the population. So there is a bit of a wait and see here to that process.
Totally understand. I know I'm out of time, but this recidivism issue, I think, is something that we need to really pay attention to in the ensuing months and years once we've got the pandemic in our rearview mirror. I'll yield back.
Thank you, sir. Mr. Cartwright is recognized.
Thank you, Mr. Chairman. And I want to welcome Director Moskoff and mention what a wonderful thing to have the first woman head of the AO and to have you testifying before us within your first 3 weeks. They're already putting you through your paces, I can see. Congratulations on that. I noticed that you come from the storied Eastern District of New York, and a lot of great judges came out of there. Congratulations for that. One of my favorites was Jack Weinstein, who wrote Weinstein's Evidence, a treatise that I relied on for 25 years of federal court practice and trials. And I think that may be what connects the two of you, Judge Moskoff and Judge Lundstrom. Judge Weinstein retired and he lives in Kansas. Is that right, Judge Lundstrom?
Well, he's from Wichita, Kansas originally, but I didn't know that he had come home, honestly. But he is a Kansan by birth, of which we're very proud, of course.
Of course. All right. Well, I want to jump into the issue of security. As you both know, we've got a rude awakening here in Washington about the importance of security for public officials on January the 6th. And I dare say you saw that on television. It's something that doesn't stop with legislators, though. It includes the judiciary. And here's what I want to ask. And Director Moskoff, I'm going to invite you to answer these questions in whatever order you want to take them. Without disclosing any specific security measures you've already taken, what would you say your biggest concerns are regarding the personal safety of the judges as well as of court staff? What are your biggest concerns regarding the safety of court buildings and offices? Are there any immediate steps we can take better to protect the courts? And how do you envision the judiciary changing better physically to protect those in the court system?
So thank you very much, Representative Cartwright, for that question. Security is one of our biggest priorities, as it is for so many of us. I think a key issue for judges is the fact that their personally identifiable information is readily available on the internet. And we saw what can happen in the tragic events with respect to Judge Salas and her family when that information can be accessed and indeed weaponized by a disgruntled litigant or someone that has some reason to target a judge or even a member of our court staff. And the legislation that was proposed last summer, which had very broad bipartisan support, focused on efforts to try and remove personally identifiable information, PII as it is known, in order to prevent or help prevent these types of attacks. Of course, you will never be able to prevent entirely these types of incidents, but removing PII is a key aspect of prevention. There are resources necessary also within the Marshal Service. Some have already been given to the Marshal Service to enhance their ability to assess threats and react to threats. But one of the things that would be critical is to stand up a resource within the judiciary itself to help identify that information that's out there on the internet, to educate judges better. And one of the things that we have proposed and that we seek is a resource to proactively monitor for online threats made against the judiciary. There has been additional funding provided for home intrusion detection systems at judges' homes. There are things that we need to do to harden the perimeters of buildings. And actually, protection of buildings is actually protection of judges, court staff, and everyone who uses our courts. And so we are hopeful that we can seek upgrades through the Federal Protective Service to the camera systems outside. We've identified since January 6th some additional resources that would be helpful to hardening the perimeter. Many of our courthouses have glass fronts and screening areas that are set back from the entrance to courthouses, mine included. And we've always been concerned about malicious actors or large groups breaching the front of the entrances to our courthouses. Of course, additional marshals, funding for additional marshals in the marshals budget can also go a long way to helping with all of the issues that we're concerned about, and that we share those concerns.
Well, good. We can talk further offline about things you don't want to be public. And with that, I yield back, Mr. Chairman.
Thank you. Mr. Womack, Mr. Amade is next, but I understand he isn't currently with us. So if it's all right, I suspect you'd like us to move on to Mr. Stewart.
I see Amadei. Oh, he must be on another hearing. So that's what the problem is. Okay. Yeah, we.
I just want to make sure I don't skip him if that's not the case.
Well, I'm looking at him sadly, but I think he's on another hearing. So.
Okay, then we'll move on to Mr. Stewart.
All right. Well, thank you all. You know, as a sidebar, I learned something interesting yesterday on this hearing. As Mr. Womack so graciously tried to yield to me, I was actually traveling in my car at the time, and it turned out WebEx mutes you and turns off your video if you're moving. So if any of you have that experience, don't try to log in while you're driving. It won't work. You can listen, but you can't participate. So I'm glad I'm just sitting in my office today. To all of our witnesses, thank you. Much has been said so far about security. I don't want to ask a question regarding that because I think you've answered that and we've emphasized that. I would like to say though, I do have some personal experience with this. One of my brothers is a U.S. federal judge. It's been something that he's been concerned about, you know, as all of you have been for quite some time. I could review the list of those who have been assaulted or in some cases killed, who are associated with our judiciary over the last year. And much has been said about security here at the Capitol. I would just like to emphasize that security of our judiciary is equally important, and it's just not getting the same degree of attention, and I think it should. And part of that is making sure that you have the resources to provide that security, that our U.S. Marshals and others are able to do that. We want to work with you to make sure that that takes place. Once again, an assault on our judiciary is as important as assault on our legislative members, and I think we have to treat it that way. My question regards how we've responded during the pandemic. Again, using my brother and other federal judges that I'm associated with. Many of them have not been to the courthouses for a long time. They're holding their hearings as we are today through electronic means. And I'm just curious what kind of feedback you're getting from that. If I were a defense attorney or perhaps a prosecutor, I would wonder whether it has the same effect and whether it can be as effective holding a hearing like that when you're not in person. And I'm wondering what you're hearing from our judges. Are they concerned about it? And how quickly are we going to be able to get back to where they're holding their hearings in courtrooms rather than via the web like we are today?
I can lead off with that if you like, since like your brother, I'm in the 10th Circuit area. You know, I think all of us would prefer to go back to life as it used to be in terms of in-person hearings. I think that is clearly preferable to most all judges I've talked to. What we have found is that for certain kinds of proceedings, whether they be first appearances or whether they be status conferences or even revocations of supervised release or something else where there's been some agreement entered into between the government and the defense counsel as to what the disposition ought to be. The efficiencies of it have been appreciated, and really the feedback from defense counsel has been that, maybe perhaps surprisingly, they find it very positive. So I think we haven't lost anything really in translation. but we haven't been doing jury trials or perhaps suppression hearings or things like that, that we're going to need to get back to doing. The one thing about that I think a lot of us have commented on, much like this proceeding today, where you and I are literally looking at each other eye to eye in a way that in a congressional hearing room, there's a great gulf of distance between the dais where you all are sitting and the tables where the witnesses are sitting. Similarly, in a proceeding that we might have virtually in a courtroom, the difference between looking at that individual eye to eye, just like this, in some respects, I feel closer to that individual who's in front of me than I do perhaps seated across the courtroom by 20 yards or however far it is. So I don't know if I'm expressing myself very well about that, but I think there are some aspects of it that are not all that bad, if you will. And I think that perhaps has factored into why the defense bar has not been negative about it.
Yeah, Mr. Lundstrom, I appreciate that, and you're right. I mean, you can be, I think, fairly effective in this format. It depends on how they're managed. And Mr. Quigley, for example, does a good job. But, and I know my time's expired, but I just think I need to make this point. You said something I think very important, and that is we have had no jury trials. And
Right.
that means that, I mean, that means significant legal proceedings have been delayed. How long can we keep doing that? I mean, that's a big deal when you say we haven't held a jury trial in our federal courts for probably a year now. And once again, that's an enormously important consideration that, you know,
I
we
think
keep moving forward with these cases, and we got to recognize that.
We're in the District of Kansas. We anticipate being able to conduct jury trials in April. Now, the caveat to that is that we have to have proper screening. We have to have proper social distancing. We have to have certain plexiglass installations, things to protect the participants. I conducted a civil jury trial in September. We conducted 2 or 3 civil jury trials in September here in the District of Kansas when there was that little dip in the way the pandemic was going. But criminal jury trials, because there's so many more witnesses involved, so many more jurors involved and all, have been where the real holdup has been. And there is a pent-up demand that as soon as that safety, green flag goes up, I think there are going to be a ton of jury trials sooner rather than later.
Yeah. Well, again, my time has expired, but I hope we all understand the importance of this, and thank you, sir.
Sure. Yes, sir.
Thank you, Mr. Stewart. We move on to Mr. Bishop.
Thank you very much, Mr. Chairman, and let me thank Judge Moskoff and Judge Lundstrom for appearing before us today. I want to talk about 2 topics, diversity fellowships and federal employee issues. So even after taking into account recent improvements, the legal profession remains one of the least diverse of all of the professions in the country. For example, African-American representation among lawyers is only around 5%, despite accounting for 13% of the general population. And I want to commend the Judiciary for recently establishing the Federal Defender Diversity Fellowship Program, which will supplement the pipeline of attorneys from all backgrounds who are qualified to join a federal defender organization, a District Criminal Justice Act panel, or federal capital defense team. Judge Moskoff, can you provide us with an update on the rollout of this new fellowship and provide us with some insight on how much, if any, of the participants' costs will be offset with the program project? Will the funding for the fellowship be used to help cover the high costs of living and transportation that often burden people from low income and rural backgrounds? And the second question, quickly, according to the Office of Personnel Management, the federal workforce is 2.1 million civilian workers. And of course, I believe it's incumbent upon Congress to ensure that the workforce has a safe and a respectful workplace. Recently, at the direction of the Chief Justice, you established a working group to evaluate the judiciary standards of conduct and procedures for investigating and correcting inappropriate workplace conduct. Can you tell us what progress has the working group made in this regard to improve the workplace environment within the judiciary, and where do you see room for future improvement?
Thank you, Congressman Bishop. Those are two very, very important areas, two very high priorities in the judiciary, and I'm happy to address them both. Let me start with diversity. One of the privileges that I have had is to serve on the Judicial Conference's Judicial Resources Committee. And as part of the committee, we have a diversity subcommittee. And the diversity subcommittee has been on the forefront of diversity and inclusion initiatives within the judiciary. Through that, I've also participated in the formulation of the judiciary strategic plan. And it was clear that across components of the federal judiciary, everyone was focused on improving diversity, whether it was the probation and pretrial offices, federal defender offices, in the bankruptcy community, bankruptcy judges and magistrate judges. And one of the things we will be doing shortly is convening a roundtable or a summit, bringing together all of those pieces from across the judiciary to share best practices and to see what we can do to moving forward to improve the diversity of the federal workforce and among magistrate judges and bankruptcy judges, which is the aspect of the bench in which the judiciary is directly involved. As you indicate, one of the new initiatives is the Defender Services Diversity Fellowship Program. And it is designed to bring lawyers, younger lawyers in their career, to help work on capital and non-capital cases within the federal defender system. One of the hallmarks of the program is that it will not be centralized here in Washington. Fellows will reside in federal defender offices across the country, will be hosted there, will be mentored by federal defenders, CJA lawyers, Capital Resource Council, and others involved in the provision of defense services, which will hopefully address your concerns about the high cost of living in particular areas. We hope to have these fellows in areas where the need is greatest. And of course, the program is open to all, but it is designed to have targeted outreach to communities that are not well represented across the federal defender system and the CJA system. And we hope that through the fellowship, lawyers will then be committed to taking what they have learned back to their communities, serve the populations that we serve, and reflect the communities that we serve. With respect to workplace conduct, so too, my service on the Judicial Resources Committee has involved me in many of the initiatives that are ongoing in the judiciary. And I must say that the judiciary, from my perspective, has made tremendous progress in standing up a new and much improved system across the judiciary to address issues of workplace conduct. There have been updates to the employee dispute resolution policies, and I'm happy to report that all circuits and 80% of the district courts across the country have adopted the new model EDR plan that has been proposed since the working group recommended changes. There have been changes to the judicial conduct and disability process that will greatly improve that aspect of addressing workplace issues. We have created the Office of Judicial Integrity and we have sought additional resources to provide additional staffing to that office. It is one of the ways, one of the new, more flexible mechanisms to report workplace conduct. So too, 11 circuits have created the position of Director of Workplace Relations. They have become central points in addressing issues within circuits of workplace conduct. They too are a new and independent avenue of reporting. They are instrumental in assessing additional needs within circuits and providing training and explaining resources and doing outreach to the court community in order to ensure that judges and employees know about our processes, that know where they can seek resources, know how they can report. Of course,
Judge, I'm sorry. I've tried to give everybody leeway, but I've got to make sure everybody gets their first opportunities, and then we'll have a second, quicker round. We'll afford the opportunities. So I apologize if we could move on, please. I'm sorry.
Thank
I
you.
understand, and I understand Mr. Amade is still not available. If that is the case, we'll move on to Mr. Joyce.
Thank you, Chairman Quigley. Your Honor, I'd like to sort of a variance on a theme that's already been brought up by my colleagues, Mr. Cartwright and Mr. Stewart. As a former prosecutor, on January 6th, unfortunately, some madness descended upon our capital and tried to obstruct the constitutional process in which we took place. Now, you can imagine, as a prosecutor, I look at that as a crime scene and say, well, wait a minute, we got to cordon off the crime scene, because as I try to explain it to folks at home, it's like dropping change on the ground. You pick it up and drop it again, it never drops the same way. You only have one shot to do it right. However, I understood and I agreed with the idea that we had to move forward and show the country that we're moving forward and that madness wasn't going to stop us from our constitutional duties. Unfortunately, the same degree of madness is now trying to influence the judiciary and the things that are taking place. I was wondering, what if in the integrity of the federal court operations and the decisions that are being made, what have you done to let these people know that you will not be impacted by the violence and the threats and the incidents of violence?
And I think the best way that we do that is by doing our jobs and doing it the way we have always done it, fairly, with integrity, objectively. And during the pandemic, I think it is critical to make sure that the public knows that nothing has deterred us, whether it is the virus, whether it is the protests that we experienced in the Eastern District of New York with thousands of people gathering in the park across from our courthouse. We had sufficient security. We could always use more, but we did not experience any issues. And I think
Thank you, Mr. Chair.
Do you want them to ask you a question?
They're still going.
Brian.
Turn your mic off, Amade.
Okay. Please go ahead.
They muted everybody's mic.
The judge
Oh.
needs to unmute.
Judge, you need to unmute. I'm sorry.
my final comment was, I think by continuing to do what we do, we've earned the respect of those who may, we have earned that respect. And by continuing to do what we do, I think we send a good message to those who would seek to try and influence or impair the integrity of our courts.
I know judges are in a tough spot because you can't really get out and broadcast that. And however, we can be of assistance in doing that, or ways you think of when you're putting together your protection systems. I think it's important to let people know that you will not be swayed. Thank you, Mr. Chairman. I yield back.
Thank you, Ms. Torres.
Thank you, Mr. Chairman, and I want to thank our guests for being here with us. Judge Moskoff, I want to emphasize to you how important it is that the administrative office and the judicial conference take sexual harassment and workplace misconduct seriously. Your appropriations request discusses steps taken to bolster the AO's Trouble Office of Judicial Integrity. But I am concerned by your assurance that, and I quote, the AO is confident the judiciary has enough resources to protect judicial branch employees. So in the last few years alone, multiple federal judges have resigned because of years-long patterns of sexual harassment and abusive conduct. Whistleblowers have raised concerns about the Office of Judicial Integrity. Your appropriations request mentions that a new judicial integrity officer came on board earlier this month. But as you know, his predecessor resigned after less than a year on the job, and the position has been left vacant for months. Fiscal year 2021, I included, for this year, I included report language directing the judiciary to expand its comprehensive training program on workplace behavior and bystander intervention, and encouraged the judiciary to expand and report on its confidential nationwide reporting system to document employee misconduct complaints. Help me understand how you plan to abide by that request and provide an exemplary workplace and protect every judge and every court employee from sexual harassment, discrimination, and retaliation. Tell us how the judiciary has the resources that it needs to actually do this job and protect its employees.
Thank you very much for that question. And I share, and as does everyone in the judiciary, shares your commitment, our commitment to creating an exemplary workplace. And again, as I said before, I've been involved in some of these issues to date, and I'm looking forward to playing a different role as director in those issues. If I may, I would just like to correct the record slightly. Jill Langley, who was the first head of the Office of Judicial Integrity, had continued in that role while we searched for her successor. Her successor has now been hired. Jill has facilitated and continues to facilitate the transition to her successor. And
is that a dual job that that person, Joe Langley, had?
She is leaving the Office of Judicial Integrity to go back home to her district, to her circuit, the 10th Circuit, where she serves as the Director of Workplace Relations for the 10th Circuit. So those were the circumstances of her transition. Our new head of the Office of Judicial Integrity is Michael Henry, and he has served in a variety of capacities dealing with issues of sexual harassment and workplace conduct. And one of his main areas in which he worked, he stood up the office at the United States Center for Safe Sport, which
Pardon my interruption, Judge, but my question is about the resources. How do you plan? Do you have enough resources? Is that why you have not asked for additional resources?
So I think we are at the point where we are seeking to augment the staffing in the Office of Judicial Integrity, and we have sought resources for that. The circuits have found the resources to hire the directors of workplace relations. All courts have employee dispute resolution coordinators. Those are often collateral duties, but they seem to work well. But it is something that, so they seem to work well. I think we're...
So pardon me again, these coordinators, they're they're insiders. And how are you going to make sure that this job or this responsibility is not being given to an abuser? How can we be confident in that?
The EDR coordinator, in our experience, the coordinators, whether they're in the circuits or whether they're in the district courts, I don't think we've ever had a circumstance where they have been involved, or not, at least not to my knowledge, where they have been involved in a workplace conduct matter. The new model—
That is really great information to hear, since we have not been privy to any of those complaints. That is why the report language is requesting that. My time has expired, but I look forward to hearing you expand more on my questions in the second round, and I yield back.
All right.
Thank you. Mr. Amade, please. Mr. Womack, do you know if he's available at this point? Is he still in the other hearing?
Hey, Mr. Chairman, it's Mark Amade.
Oh, there you are. Please go ahead.
Hey, thanks for your patience with me.
Well, I was patient. Mr. Womack, he was ready to cut you loose.
You know, he's kind of cranky. I think it comes from that Gulf Coast air that kind of has an impact on him some days.
We can get into that later. I don't want to eat up your time.
Okay. Here's what I'm, first of all, I would like to know from Judge Blanton as well as Miss Spinder, is where are we at in the federal courts in terms of your employees being vaccinated for COVID? I'm assuming that in those jurisdictions where your trial courts and your appellate courts are those people vaccinated?
So, Congressman, as you may know, the federal government through HHS has created certain categories of prioritization that help inform state governments as to how to dispense the vaccine.
Correct.
But it is largely up to the state authorities to determine their own priorities. And as a result of that, there are widespread differences across the country. In some states, federal judges and court employees have been vaccinated. In my state, New York, we do not fall under the state's priorities. Probation and pretrial officers can come under the law enforcement prioritization, which has been made in most, if not all, jurisdictions. And one of the other key constituencies within the federal judiciary are our federal defenders. And I think there, again, in my state, that is a big issue. Although the Bureau of Prisons has been given an allocation of a vaccine for its staff and for defendants who are incarcerated, the federal defenders who are their lawyers still need to rely on remote technology in order to safely meet with their clients for the most part. So it is, we do not have one single standard across the federal judiciary for who can get vaccinated and who can't.
Judge, do you have anything to add?
I want to say this, that you raised an excellent point. And I think that Mr. Stewart's question and other questions about speedy trials, and I won't eat up your time here, all get back to this. As you know, we've been vaccinated, and I think that I'd like to talk about this with Mr. Womack of going forward, of talking as a committee about, if we're talking about justice moving forward, finding out a way for the federal government to play a role in making sure that this moves forward. Sorry to eat up your time. I'll give you as much as you need.
Hey, Mr. Chairman, I appreciate that. To make it really clear here, it's becoming more and more frustrating to know, and you've hit the nail on the head, my staff in Nevada can get vaccinated. Okay, and they've made appointments and they're going to do it. Now, mind you, each state is different, as Ms. Moskoff has indicated. But I'm sitting here going, there's no consistency in the federal judiciary, and I'm not blaming the judiciary. I'm just saying at some point in time, as we're getting ready to open it up for everybody else, at some point in time, I think we need to take care of business in terms of those core functions. And obviously, the function of the judicial branch is one of those, as well as, Mr. Chairman, just the function of our own staffs who are basically here. I mean, I was just on a hearing with the administrative office of the court. The AOC people who have to work in the building, guess what? They're not vaccinated. They can't work from home. And so as we're sitting here getting towards this point in time, I don't think it's the point where it's like, hey, somebody's better than somebody else. I think a good faith, objective look at the functions that these various folks provide is something that, quite frankly, ought to get them into the, okay, we've done everything we can for you. You know, we're talking about the mental health of everybody. Well, COVID's a piece of that. And I won't go on beyond that. The only other, thank you, I'll look forward to working with you. The only other thing I want to say is, for both of these witnesses is, I know that different judicial districts are different and all that other sort of stuff. But one of the things that's kind of coming forward, at least in terms of our own neck of the woods, is, are we building in silos in all this security, at least for purposes of communication? Because whether it's, you know, the Library of Congress or the federal courthouse or the whatever, the one thing that I would ask is that we think about not only what the interconnectivity is in terms of the marshal's office or whomever, but also their ability to cross-thread, if you will, with other local law enforcement, whether they be other feds as well as the state and local folks, since the idea is to have all assets available. And so that's one of the things that we're going to be keeping an eye on when we talk about, okay, we got to up our game on security, but one of the things we need to do is make sure that there's not a silo between the federal courthouse and the local sheriff's office or the local FBI, as well as the U.S. Marshals and all that other sort of stuff. So I just want to put that on the radar screen.
No, we will, and I'll allow the judges to respond. I'll be part of the first part of the next round. But Ms. Kirkpatrick has been so patient, I'll let her proceed. And then we'll get to a follow-up on your point as well.
Good, thank you.
Thank you, Chairman Quigley and Ranking Member Womack. As you know, this is a really important hearing to me.
Ms. Kirkpatrick, I believe your screen froze. We're able to help Ms. Kirkpatrick with the technical difficulties.
Mr. Chairman, we'll work on that.
Okay.
Yeah, I suggest we move
Sure.
until she can free up.
As soon as Ms. Kirkpatrick is back, so what we want to do is we'll go into the second round and then give her all the time she needs when we come back. Very quickly, and I'll ask my colleagues and those responding, let's try to do 3 minutes this time. And I do want to afford you the opportunity to respond to, if you desire, what was brought up at the end about security. But I also, you all put forward a security stimulus request of 122.5 million, which 10 million for additional staff and 112 million to conduct a physical security assessment. Can you briefly, whomever you decide to answer, give us your sense of this and why it's important and what it would do?
Do you want to start with that, Judge Moskoff?
Sure. I think these are evolving needs that have largely come from the lessons learned from January 6th. We've always been concerned about finding ways to harden the entryways of our courthouses. As we've talked about, we've always been focused on mitigating vulnerabilities before they can be exploited. And so 113 million of that request is to secure entrances and screening areas. And the additional $10 million, which does require authorizing legislation in addition to funding, is to enhance the judiciary's threat vulnerability management. And this is the judiciary's effort. This is to fund the judiciary's effort to identify and remove that personally identifiable information before it can be used against a judge. And currently we don't have resources to stand up that type of vulnerability management program, and it would be a complement to what the marshals do in actually once a threat is identified and investigated by the marshals.
Chairman, you're muted.
Judge, you want to add to that?
No, I think the director covered that quite well.
Ms. Kirkpatrick, is she back on?
Not yet, Mr. Chairman.
If not, Mr. Womack, please.
Thank you. My last question is going to be on cybersecurity. The request is a $9.1 million increase for internet firewall services. You know, we all know what happened on the SolarWinds debacle. To the extent that you can say it in public, if you can say anything, has the judiciary been impacted by the SolarWinds breach? And if so, what steps are you taking to mitigate? And then as follow-ups, how closely does the judiciary work with cybersecurity experts in the executive branch to ensure that you guys are all connected to the latest threats, supply chain concerns, mitigation techniques, all of that kind of stuff? And how will funding in your request enhance your cyber protections? And is it sufficient to address the growing cyber threats? I'll leave it there.
And I can start.
Okay, whichever way. Either one.
I was going to start generally by saying that unfortunately, it looks like we are in good company with respect to the issues related to SolarWinds, but I do have to be very careful with what we say. We have been working with law enforcement actively, but there are two things that I can speak about. First, we are working with the Department of Homeland Security's Cybersecurity and Infrastructure Security Agency, CISA. They are conducting a forensic investigation of the impact or any impact of the SolarWinds situation. And those findings are pending the results of that forensic investigation. We've also given guidance to the courts proactively while we are trying to understand what the impact may have been to protect highly sensitive documents. Sensitive documents that could harm the United States, harm the judiciary, litigants, or others. These are documents that are generally, in most cases, in fact, I think in all cases, sealed. And so we don't anticipate any type of public access issues. But we have counseled courts to look at their practices and to adopt orders to ensure that those documents are maintained either in hard copy or on some type of a standalone computer system that isn't connected to the internet or any other system that could be compromised. So we are working actively to identify any impacts from solar winds and to take the necessary steps to understand that and to protect the information, the very valuable information that is housed within our systems. And I'll leave the fiscal issues to Judge Lundstrom.
Sir, and if you could, please go ahead as somewhat quickly as we're trying to get through the second round, sir.
I think it's really all in the materials there, and Ranking Member Womack mentioned the increase that we're requesting, and it's our best assessment of what we are able to do if we had that funding to be able to shore up our security on the internet stage.
You follow up, Mr. Womack?
No, that's it, other than to send my condolences to Judge Lundstrom on the loss by Kansas last night.
Oh, it's a heartbreaker.
As an aficionado of basketball, but hey, look, the silver lining is Kansas State won. I know you probably care less about them.
No, that's
there
not
you
a
go.
silver lining for a Jayhawk. Now, come on.
Fair enough. We're gonna go back to Miss. We're gonna go back to Miss Kirkpatrick. For all you Kansas folks, if this makes you feel at home, we'll go back to Miss Kirkpatrick. We'll go back to Miss Kirkpatrick. She is still in the first round. We're sorry for her issues.
Thank you, Chairman Quigley. I think we've got it worked out now. So
okay.
I want to thank Chair Lundstrom and Director Moskoff for appearing before the committee. As you know, I represent a border district in southern Arizona. So we are especially interested in immigration-related issues. So I understand that surges in immigration-related cases leads to increased need in federal defender services staffing. So could you please talk through staffing needs, especially in regard to immigration, and how the 7% increase in funding you have requested could meet those needs?
Thank you, Ms. Kirkpatrick. As you know, the really disproportionate number of criminal defendants arise out of the 5 border court districts, much of that having to do with immigration workload. And that particular workload did not decrease during the pandemic as much as some other criminal filings were. So as a result, the burden on defenders, both the federal defenders offices and the the Criminal Justice Act appointees, continued to build. We think that the work measurement formula that has been developed for defenders adequately captures those needs. Now, this past for fiscal year 2021, because of some unanticipated needs, such as the McGirt versus Oklahoma decision, which altered the way in which certain Indian nations were treated under state versus federal law in Oklahoma, and also Arizona's being adopted into the opt-in program for fast-tracking capital habeas cases. Some resources were reallocated among federal defenders' offices accordingly. We're trying to catch back up with that in our 2022 request, which would take our federal defenders up to a 98% of their staffing formula, which would be about as much as practically they would be able to maintain just in the ordinary course of hiring people and people leaving and that sort of thing. So it's always a huge issue. Our defender program is, I think, one of the jewels in the crown, if you will, of the federal judicial system. And there are particular needs in the border courts that we are trying very much to address.
Well, we really rely on the defender services in southern Arizona. So I want you to know that's a top priority of mine. Anything I can do to help with funding there, let me know about that. So, you know, you've already pretty much addressed the security measures. I just want to highlight a little bit about, I have a rural district, largely rural district in southern Arizona. And so, you know, what kind of online services are being offered to my rural folks? And I'd like to hear about measures taken to increase cybersecurity in rural Arizona?
I think I think rural versus urban or metropolitan doesn't make a difference in the areas that you have highlighted. We are making proceedings accessible to the public in rural areas as we are in rural areas, or courts that serve rural areas as we are in others. I think sometimes, and we even see this in urban areas, the technology available to the public is not often good. And so some of the things that have been done is to, if courthouses are still open and if we can have a limited number of people in the courthouse, we still make we make a courtroom available with a video monitor so people can still come if they don't have the technology to join. So I think that we don't recognize those distinctions. We just use different technology, different ways to achieve the same results in courts that service rural areas as we do across the rest of the country.
So one of the problems we found with cyber is interoperability. Is that a problem that you're having to deal with in rural parts of the country?
Honestly, that's an issue that I don't feel well prepared to address. And if I could get back to you on that, I would really appreciate it.
Sure, just get it back to the committee and we'll make sure every member has access to your response.
Thank you so much. Thank you, Mr. Chairman.
Absolutely. Cartwright's gone.
No, Cartwright's here. Thank you, Mr. Chairman.
Mr. Cartwright, thank you.
And Director Moskoff, again, I want to congratulate you on the new position. You certainly had big shoes to fill, replacing Jim Duff, whom we got to know. But it looks like you're on a good trajectory toward acquitting yourself very well in the position.
Thank you.
And I do, 3 weeks into the job, I understand, but we expect you to fill up your bookcase a little more the next time we see you. But seriously,
no background shaming.
We are. One thing that I will say, I have thought for decades about the federal courts is that they have carried the proud mantle of both of preeminence, really, in both technology, new and in speed of adjudicating civil cases. In fact, they've made a great effort over the years of keeping track of statistics along those lines, particularly with expeditiously moving civil cases. Well, my colleague Chris Stewart and I have both mentioned now about the concern about the civil backlog because of the lack of federal jury trials happening. Obviously, there's going to be a big pile of cases in your inboxes, all of the federal district court judges. Can you share with us what your ideas have been about how to move those? Are you going to use magistrate judges more? Are you going to do summary jury trials? You folks are masters at innovation, and I'd like to hear some of your ideas so far.
So on the civil side, oh, go ahead, Judge Lundstrom. Why don't you start? And then
you go ahead. No, you go ahead. Go ahead. I like to look at your bookcase.
So on the civil side, I think judges and litigants have approached the issue, even during the pandemic, in creative ways. There have been Zoom trials on the civil side in complex patent cases, in other commercial cases. There haven't been a lot of them. I'm not sure if we have had jury trials on the civil side, but litigants understand.
They have in Western Washington.
Yeah.
Western District of Washington. Yeah.
So some courts are experimenting with that, and I would expect that to continue. And so people are trying to be creative. In terms of when we really start going, I think we will have to think about using magistrate judges, about using our visiting judge program, about seeing about the ways that we can use technology perhaps to try and increase the number of cases we can do. But there's only so much you can do, I think. And that backlog will take some time to dig out from.
One of the real, sorry.
Go ahead, Judge.
I was going to say, one of the real problems in moving the civil cases now as the logjam breaks is the priority we need to give to criminal jury trials. And the courtroom space is more limited because we only can hold proceedings in certain size courtrooms to accommodate folks and be socially distanced and put in the personal protection infrastructure and so forth. That's probably the biggest impediment to actually getting civil trials conducted. But we're going to do our best. It's important.
Well, Chairman Quigley and I are a phone call away, so we're here to help. And I yield back, Mr. Chairman.
Thank you, Mr. Bishop. And again, we're in the 3-minute round, so please try to fit your questions and answers into that slot, please. Thank you.
Chairman, as a longtime member of the committee, I take pride in being a responsible steward of federal spending. I believe we have to strike a balance between adequately funding our programs with responsible constraints on the national debt. And I was very pleased to hear Judge Moskoff, as you mentioned a number of the steps that the Judiciary has undertaken for cost containment measures. I thought that was remarkable. Can you just tell me whether or not there is any additional support that we can provide in Congress to help you with these successes? You went through a long list of items that you have been able to undertake for cost containment. Is there something else that we can do to help in that regard?
If I can jump in there on that, Congressman Bishop, in our request in specifics, we have a $10 million request to help with our No Net New program, which is in the space area where we have a rule that you can't add space without taking space off the books. But sometimes to be able to do that, there are renovations that have to take place. So we've requested $10 million in this 2022 budget to continue that program, and it's taking money off the books enough that more than pays for it over time, but we have to make an upfront expenditure. That's the kind of thing that you all can assist with through the appropriations process for sure.
Thank you. I'll yield back, Mr. Chairman.
Thank you, sir. Ms. Torres is recognized again.
Thank you, Mr. Chairman and Judge Moskoff. Just to go back to our conversation earlier, it seems that many of the recent concerns with the judiciary has to do with the lack of transparency. Sexual harassment flourished in the darkness, and we've seen and judges' chambers are notoriously closed off. Similarly, many of the rules that apply to other federal agencies don't apply to the AO and the judiciary. You are not bound by the same federal contracting rules, for example, as the executive branch, and you don't have an inspector general. I'm happy to see your request to build out an Office of Compliance and Risk to bolster the AO's ability to address internal control weaknesses and other audit recommendations, but I am very concerned that the office work will be undermined unless we know what's going on. So will you commit to making those audit recommendations public? And if you can expand on my previous questions.
Congresswoman Torres, I'm not prepared to commit to making public the audit findings. I just don't know enough about the process yet, and I hope you can appreciate that. I don't want to do any or commit to something that might be in violation of law But I certainly understand Congress's oversight role of the judiciary and its oversight, and this subcommittee's oversight over the resources that it provides to the judiciary. And we are very mindful of that, respect it tremendously, and will ensure that you have the information that you need consistent with what we can turn over to allow you to exercise that oversight function.
It's unfortunate that you cannot commit, Judge, to basic transparency and accountability. I think that is the nexus of the issues that have been brought forward by the lack of protection for whistleblowers, the lack of respect for employees, and the sexual misconduct allegations that we have seen. I have 35 seconds left. I'm going to turn that time over to you and hope that you can be a little bit more transparent.
I am committed, and we are committed to transparency and to ensuring a safe workforce. We do have provisions that address retaliation. You cannot retaliate against someone for bringing a complaint forward. The new judicial conduct and disability rules require judges to come forward if they know about misconduct within the judiciary, including involving a judge. And if they don't, it is grounds for misconduct finding. So there are strengthened rules, strengthened procedures to address all of the issues that you raise. Of course, we can always do more, and we are committed to doing more.
And we need to do more because the issues continue, and I'm out of time, so I'm going to yield back.
Ms. Torres, you're out of time, but the discussion will continue, and I pledge that we will continue to work with you and to continue to communicate with the judge on this matter to the extent we can as we learn more. And as you know, she's 3 weeks on the job. So let's continue the dialogue.
That's why I was kind and nice, Chairman. Thank you.
No, I understand. I appreciate that. Mr. Womack, do you have anything to add, sir?
I do not, and ready to go eat.
Me too. Without objection, I have a question for the record on the Abraham A. Ribicoff Federal Building and the U.S. Courthouse and Hartford Courthouse, and a letter from the Federal Law Enforcement Officers Association that I'm submitting for the record. We will now conclude today's hearing. I ask members to submit any remaining questions in writing for the record. Judge and Director, we want to thank you so much for your service and for your assistance today. And if you respond to any other additional written questions in a timely fashion. With that, this hearing is adjourned, and thank you all.
Thanks, judges.
Thank you.